Hello there, Tom Hickey here, DCU. I wanted to talk to you in this video, perhaps there'll be 2 or 3, hopefully short videos, about Article 40, Section 1 of the Irish Constitution, the Equality Clause, and in particular about recent developments, recent jurisprudence. So there have been 2 or perhaps 3, significant judgments handed down in recent years in this area of constitutional law. In particular, a judgment handed down in the case of Donnelly and the Minister for Social Protection. Robert and Henry Donnelly against the Minister for Social Protection it was a case brought by a family, or I guess a father and infant son, challenging the constitutionality of a provision of legislation, social welfare legislation, that had the effect of excluding them from a particular and significant social welfare payment, or social support, you might call it. And they argued that their exclusion breached the Equality Clause. They lost in the High Court, they lost on appeal before the Court of Appeal, and they lost again before the Supreme Court. A unanimous 5-judge Supreme Court ruled against them in the summer of 2022, and there was one judgment written for the court in that case, written by Miss Justice Iseult O'Malley. That judgment is very significant, I would say. She casts her eye back over several decades, really, of Irish constitutional jurisprudence in this particular area, and I suppose revises it to an extent, or recapitulates it, you might say. And that judgment now, and applies it, of course, in the context of the facts of the Donnelly case. And that judgment now, I would say, is the reference point now for Irish lawyers and judges in this area pertaining to Article 40, Section 1. It's likely to remain the reference point for the next, let's say, decade or more. So this video is not a deep dive into the O'Malley judgment, but it's intended as a kind of a supplement to the judgment. In other words, I think if you're a law student, certainly a constitutional law student, have to read that judgment, right? There's no getting away from it. You've got to read that judgment yourself. But this video might kind of help you in that task. The other case in particular that I wanted to reference was, and we'll talk about, is the case of O'Mara and the Minister for Social Protection, which was decided by the Supreme Court in, I think, 2024, and also was fundamentally, actually, an Article 40, Section 1 case. In that case, I won't go through the facts of it now, but the applicants win their case. They win their challenge on the Article 40, Section 1 point. In other words, the Supreme Court overturns or rules unconstitutional a particular provision of legislation that had the effect of excluding that family, a Tipperary family, from a particular social welfare payment. And then the third case that I would like to consider is a case called ZG and EW against Ireland, decided by the Supreme Court in 2025. Another tragic case. I mean, I'll go through the facts of these cases again, but I mean, O'Mara was also a tragic case, as we'll see. But in EW, he was a 14-year-old boy when his mother was murdered while on holiday abroad. That is to say, the mother and the 14-year-old boy had been living together as a single-parent family in a rental apartment in Dublin. She was the statutory tenant. The Residential Tenancies Act allowed some people to succeed to a statutory tenancy on the death of the tenant, but not a 14-year-old child. In other words, I think if you were a child of the tenant who was more than 18, you could succeed. If you were the spouse of a tenant, you could succeed, but not if you were a 14-year-old boy. And he argued, or it was argued on his behalf, that his exclusion was a breach of the Equality Clause. Let's say, that was an interesting case because the majority of the Supreme Court ruled against him, but there were 2 dissents, and in particular there was Miss Justice Aileen Donnelly's dissent, which was an interesting dissent of the Chief Justice. Donald O'Donnell handed down the judgment for the majority, so there's a kind of a contrast there, which I think is worth maybe considering. Now, I don't want this to be a general and a lengthy lecture on Article 40, Section 1, but I do think it's worth maybe pausing for a moment on the wording or the text of Article 40, Section 1, and just looking at the formula that's used So it says, it opens with a kind of a statement of principle, constitutional, or you might say even moral principle. Um, all citizens shall, as human persons, be held equal before the law. So you do get that notion of personhood or human personality, if you like, dignity, in the statement or assertion of constitutional principle. And then there's that kind of proviso or qualifying clause, if you like, and it essentially says, well, this shall not mean that the state can't treat people differently. This shall not be held to mean that the state shall not, in its enactments, have due regard to differences between categories of citizens. So, in other words, what you get from that formulation is this essential idea that it's not constitutionally tolerable to treat people differently for no good reason. But it is perfectly constitutionally acceptable, and of course it might sometimes be constitutionally be necessary, or it might be in the public interest to treat people differently. You think you can't have a system of social protection if you can't categorize between different people in different situations. You know what I mean? So really most of the case law, I mean, historically, if you go back to the 60s and the 70s, you take a case like de Burgh and the Attorney General, which I won't really go into here, or Vic Vahuna not so much, but the other case of Nicolau's case. If you look at your textbooks, for example, the Doyle and Hickey textbook in the Constitutional Equality Law chapter, you can go through and you can see that older case law. You'll find discriminations between categories of people that, to modern eyes, look very, very strange. So in Nicolau, for example, unmarried fathers could be dismissed and ignored in an adoption context, whereas unmarried mothers could not be ignored or dismissed. Was that arbitrary or non-arbitrary discrimination? Well, to modern eyes, it looks like arbitrary discrimination. Back then, it wasn't, because of cultural kind of thinking. Similarly, in de Burgh and the Attorney General from the mid-1970s, you had legislation, it was older legislation, the Juries Act, I think from the 1920s, that excluded women from serving on juries. Now, again, it was a little bit more complicated and we don't need to get into it. Women could opt in under the legislation, but of course most women didn't. But the question was, well, women, I suppose, were kind of prima facie excluded. And the question was, well, was that difference in treatment between men and women arbitrary or non-arbitrary? I mean, were there good reasons for it, or were there not? Well, actually, there was disagreement, I think, on the court at that time on the question, which is worth maybe looking at. Again, I think it's dealt with in the textbooks, but essentially the majority formed the view that to draw that particular line in that particular way at that particular point, just simply between women on the one hand and men on the other, that was arbitrary, that there was no good reason for drawing the line in that way in the particular context, and so the legislation was invalidated. But the modern cases are more challenging because the lines aren't as, let's just say, to modern eyes, of course, aren't as obviously, let's say, arbitrary. So no, you don't really get legislation, certainly not enacted in the last, let's say, 20 or 30 years, that excludes women from something like a jury or from public transport, or is going to exclude a whole category of citizens in such a blunt and kind of, as it were, evidently arbitrary way. So the modern litigation is more, frankly, interesting, because, you have lines drawn, obviously, between categories of people where this category would be entitled to a particular, lots of the case law, as I've said already, is about social protection payments of different kinds, and this category will qualify and be entitled to it, meaning that category isn't. And typically what you'll get is a litigant who's in the category that's excluded, but who really, to all intents and purposes, kind of really looks like a litigant or a person, a citizen, I should say, who should be in the other category. Fairness would seem to require that they would be in the category that would be entitled to the, let's say, payment or benefit or whatever it might be in question. Now, this brings me to maybe the other, maybe foundational idea, very much related to the one we've been talking about, in the jurisprudence, and you see this referenced a lot by different judges at different times, including by Isil Tomali in Donnelly and the Minister for Social Protection. She says, look, to legislate requires the drawing of lines. And in any situation, there will be persons on the margins of a category who might have a strong claim to be included, and by that she means a strong claim in kind of morality, or a strong claim in political morality, let's say, to be included, but who are lawfully excluded. And what she's getting at there is really the idea of the separation of powers. In other words, she's saying, look, in our constitutional system, it's the Oireachtas that gets to legislate. The sole and exclusive authority to make laws for the state is vested in the Oireachtas, Article 15 of the Constitution. And she's also kind of saying, and I'm paraphrasing here, obviously, look, that it's not just that the Constitution says that, it's that kind of democracy requires that. And it can't be a situation, she's saying, that I as a judge can come along subsequently and just say, well, you drew the lines there, I would have drawn them just a little bit slightly differently, so as to include these poor litigants who really should have been included in the first place. And so I'm just going to tweak the line, because if she can do that, well then she's effectively legislating, or the courts are effectively legislating, or I suppose they're becoming more and more like a third house of the legislature, if you like. So that's why it's quite difficult for modern litigants to win, because the Oireachtas isn't enacting legislation that says, well, women should be excluded from work in the public service, or people of a certain religious or religious belief system are excluded from public transport, or whatever. In other words, what you don't see very often nowadays, for the time being, until the public political culture changes perhaps, is legislation that very bluntly and very unthinkingly and arbitrarily and rigidly and for no good reason draws lines between categories of citizens. And so, it's easy to win cases like that, because you might say, well, the distinction drawn is not just unwise, or it's not just a little bit unfair, or it's not just a case of, well, maybe actually you should draw the line slightly in a different place. It's totally irrational, and so it is easy for the court to come along and invalidate it. But of course, you don't get that legislation nowadays. You get legislation where the Oireachtas draws the lines here, and where certainly arguably, if you were of a different political hue, for example, you might draw the line just over there. And you might say, well, why isn't the line drawn over there? Well, because that's a political choice. And democracy demands that choice is made by, the Oireachtas. And so, look, that fundamentally is what this whole area is about. These cases, O'Mara and in particular Donnelly and Minister for Social Protection, are about. And we will, in the next video, look at the facts of Donnelly a little bit more carefully, look at the facts of O'Mara a little bit more carefully, and look at what in particular Judge O'Malley and Mr. Justice, the Chief Justice O'Donnell, said in O'Mara. Remember, actually, the litigants in O'Mara actually won. They managed to jump the hurdle, whereas the litigants in Donnelly, unfortunately for them, didn't manage to jump the hurdle.